Of all the arguments I have heard in the Kyle Rittenhouse shooting, the most pervasive is clearly the one that he didn't belong there. What was he doing there? Is this a valid argument? Should Kyle give up his right to self-defense because people think he didn't belong there? Hello out there. I'm trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
Okay, so let's take a look at this. There are kind of two facets to examine this argument. And one of those is the legal basis, and the other one is sort of a common sense deal. So let's take a look at the legal side first. And the question now becomes that if Kyle has been charged with murder, is the fact that he was from out of state have any bearing whatsoever on his claim of self-defense? And the answer to that is no. Let me explain why. There is a doctrine in the U.S. Constitution surrounding the ideal of right to travel. And this concerns basically Kyle because he was originally from Illinois and he traveled to Wisconsin. Now, unlike what a lot of people think, he did not travel to Wisconsin to engage in a protest. He actually traveled to Wisconsin the night before. The idea was that he was going to clean up graffiti at the local high school the next morning. Suppose he did travel to Wisconsin to go to the protest. What does the law say? Okay, let's take a look at the doctrine of right to travel. Okay, so let's take a look at what the law says about this. This is from the Law School of Cornell. Pretty credible. And this concerns the right to travel. The doctrine of the right to travel actually encompasses three separate rights, of which two have been notable for the uncertainty of their textual support. The first is the right of a citizen to move freely between states, a right venerable for its longevity, but still lacking a clear doctrinal basis. Now, this is the law that the sovereign citizens get fouled up all the time. They misread this and assume that that means they don't have to get a driver's license or register their vehicles. The Supreme Court has already blown that argument out of the water, by the way. So if you're a sovereign citizen and you think so, let me know. I'll show you where the Supreme Court has ruled otherwise. The second, which interests us, expressly addressed by the first sentence of Article 4 of the Constitution, provides a citizen of one state who is temporarily visiting another state the privileges and immunities of a citizen of the latter state. In other words, Kyle is from Illinois. He moves into Wisconsin temporarily. And whatever privileges and immunities that Wisconsin provides its citizens, it must provide him as well. We won't worry about the third one, not really relevant to this argument here. Now, let's read a little bit more about privileges and immunities. This is also from Cornell. The Privileges and Immunities Clause of Article 4, Section 2 of the Constitution states that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Now, by the several states, they mean all other states. That's how they wrote things back then. This clause protects fundamental rights of individual citizens and restrains state efforts to discriminate against out-of-state citizens. However, the Privileges and Immunities Clause extends not to all commercial activity, but only to fundamental rights. And this is what allows a university to charge out-of-state tuition that's higher than for in-state, for example. It says here, the Privileges and Immunities Clause extends not to all commercial activity, but only to fundamental rights. Now, I wonder what kind of fundamental rights they're talking about here. Let's see here. Let me think. I know. How about the right to self-defense? Could that be a fundamental right? What about the Second Amendment of the Constitution? Do you think that is a fundamental right? Of course. Right to self-defense is maybe the most fundamental of all. So you see that the Privileges and Immunities Clause of the Constitution does not allow Wisconsin to take away Kyle's self-defense rights simply because he's from Illinois. There is no legal basis for discriminating against Kyle because he's from Illinois here. None. And if you disagree, read. It's right there. Now you may wonder, well, I still think that he didn't belong there. Well, first of all, the law doesn't care what you think. That's your opinion. There's no law that says that Kyle didn't belong there. He's an American. He can travel anywhere he wants in this country. And he can go to Kenosha if he wishes. He has every right to be there as anybody else that was there. Now, what about from a logical standpoint? Does it make sense that Kyle cannot claim self-defense because, well, he didn't belong there? Okay, so let's take a look at this from an analogy. And I have to be careful with analogies. You cannot justify an argument with an analogy, but you can clarify an argument using one. So let me go ahead and use an analogy here that might help you understand my stance on this idea about Kyle not being where he should be. So let's suppose that you have gang territory and a certain gang has roped off a certain area that it claims is its own territory, and you as a private citizen have been told you can't go there. Now, these are public streets. You should be able to go to those streets if you want to. However, you know fully well that entering those streets opens yourself up for attack. So suppose what you do is then say, look, I want to go into that territory, that neighborhood. I'm an American, damn it. That is an area where I can go. It is public streets. There's nothing that they should be able to do to stop me. Now, as a citizen, do you have that right? Absolutely, you have that right. No gang can tell you not to be able to travel down a certain street. So what do? Well, it's dangerous, and so you can put a gun on, and you're going to walk down there, and you're going to say, look, I'm not looking for a provocation here. I'm not looking to start something, but damn it, I want to walk down the street. I'm an American. I can do that. And so you get attacked, and you use your gun in self-defense. Have you broken the law? No. Think about what we would be advocating if the law came and said you did. You'd be allowing gangs to simply rope off whole areas for themselves and essentially intimidate people into not entering them. If you feel that you have the right to go to a certain area, you should have the freedom to do so. And people will argue you had no right to be there. You didn't belong there. That was the other gang's territory. You should have known there was going to be some trouble. They're wrong. That is a very poor argument. Now, a concealed carry expert will tell you it would have probably been not a good idea to do it, but from a principle standpoint, you have the right to do that. The public cannot intimidate you into not going into certain areas, being certain places, just because trouble might follow. Now, Kyle went to the protests, and a lot of people are saying, well, he didn't belong there. He belonged there just as much as everybody else did. Joseph Rosenbaum didn't belong there. Did Anthony Huber belong there? What about Gage Grosskreutz? Did he belong there? There was a curfew in place. Kyle broke the curfew. So did they. So why doesn't this argument hold on to the other people there? Why is it only applied to Kyle? So suppose that Kyle tried to shoot one of the protesters, and the protester defended himself by bringing out his own weapon and shot Kyle first. All of you anti-Kyles would say, good, excellent. Kyle tried to shoot him, and this person defended himself by taking out his weapon and shooting Kyle. Think that's a good argument? Remember, the people that Kyle would have shot didn't belong there. That's your argument. And therefore, according to your argument, they didn't have a right to self-defense. They didn't belong there, so they're not allowed to defend themselves. That's your argument, not mine. Then all of a sudden, the anti-Kyles go, oh, well, now, wait a minute. Now, that's different. Really? Why? How's it different? Explain that to me, how that is different. When put in those terms, it becomes pretty obvious as the problem with this argument, that somehow he needs to go to prison because he shot somebody where he didn't belong. Believe it or not, Kyle is entitled to walk the streets of Kenosha, Wisconsin just as much as anybody else, even those from Wisconsin. Even a person who was born and raised in Kenosha, Kyle has just as much right to be in Kenosha as that person does. Just remember, Kyle may have been foolish in some of the things he did that night. If he was my kid, I would not have advised him to go to the protest. But being foolish is not necessarily illegal. And just because you make a mistake in judgment doesn't mean you break the law. Self-defense laws in Wisconsin are well defined. And you can look them up. I even did an entire video on self-defense laws in Wisconsin. Went through line by line by line. Even looked at case law. Kyle's shootings, self-defense. Sorry. And the fact that he belonged there or didn't belong there has no bearing on that whatsoever. Press like on the video and subscribe to my channel. I got more videos coming.